strategies, and each conclude with recommendations using both judicial and non-judicial strategies to help address problems with investments in Africa. After our speakers, we'll have some short reflections from advocates and activists before opening for Q&A. Please feel free to send any questions using the question function to myself or everyone, or raise the questions during the open space of our agenda. And Benjamin, yes, I'll give you maybe some time. Thank you. What are the options for accountability and remedy for negative impacts stemming from the flow of money? Barriers to domestic legal accountability are plentiful, and Benjamin will speak more to this. But to provide a sense, the cost or lack of access to legal support, geographic distance between communities and courts, and judicial corruption and delays can all have an impact on whether communities can use their local court system to raise grievances. There are a few known examples of quasi-judicial regional commissions, tribunals, courts, and other bodies leading to judgments that communities in Africa have used to enforce their rights. However, the lack of an enforcement power from these bodies is a contributing factor to them not being always as effective in protecting communities. And so there's this well-known accountability gap for international financial flows, which has led to a lot of
student card and send it to you.
Could you please mute yourself? Thank you. And so, as I was mentioning, this lack of robust domestic judicial options have led to the proliferation of Sorry, I was accidentally put on mute. For non-judicial options, there are a couple of sets of key actors operating in this space. One is the what are called independent accountability mechanisms, and Robi will go into more detail about what we call them IAMs are, but these are non-judicial mechanisms that have been developed at the multilateral institutions. They are independent from the management of these institutions that help design and implement the projects with clients, and they usually report to the shareholder governments. And so these are options for communities to raise complaints concerning the investments that these multilateral institutions have financed, such as the World Bank and others. And as I mentioned, Robi will go into more detail into how these function and how they operate. Another option for non-judicial mechanisms are what are called national contact points, which are mandated for states belonging to the Organization for Economic Cooperation and Development, which are, I think, the 40 or so largest economies in the world. National contact points are tasked with receiving complaints concerning a set of guidelines that guide responsible business conduct called the OECD Guidelines for Multinational Enterprises. And so with the national contact points, communities can file a complaint concerning a private business, say maybe Monsanto, that's operating abroad, and say that the company has violated the OECD guidelines. And then the national contact point will facilitate mediation process to try to address the grievances. In addition to independent accountability mechanisms, or IAMs, and national contact points, there are several other mechanisms that may operate at the project level or associated with voluntary initiatives of codes of conduct, such as the EITI with extractives, or the RSPO for palm oil. But despite the fact that these mechanisms exist, there's still several barriers to accessing remedy. First, investors have to have these mechanisms. And so although some institutions like the multilateral institutions have non-judicial options for complaints, others do not. And so a key example, as many of you all know, is Chinese financing. Currently, there are no accountability mechanisms where communities can raise grievances concerning Chinese financing. The same is the case for USAID financing, so development financing from the US government, although the US Congress recently just required USAID to develop an accountability mechanism, which we're really excited about. Another barrier is that even when these mechanisms exist, it's hard for communities to know who's financing the project and that these accountability mechanisms are available to receive grievances. And so there are definitely a lot of challenges to accessing justice, which Benjamin and Robi will get into more. I will stop there and we'll turn it over to Benjamin and then come back for the Q&A. Thanks. And Benjamin, you are on mute.
Thank you very much. Thank you very much, Stefania, for this introduction. I'm very happy, I'm very delighted to be a part of this session today as we launch this report, a very important and valuable report on access to remedy. Very sorry for these interferences. So yes, I was saying that ACCA is delighted to be here today for the launch of this important report. It has been a very pleasant journey with Accountability Counsel since we have started working on this report. Very happy that this is something coming from the experiences of our membership and communities across Africa, and at the same time that can provide a kind of guideline or guidance to our communities to help them understanding what is access to remedy and what are the avenues that are available to them. This is exactly the very point that I have been asked to speak about today. So I would like to share some slides for my presentation. I will just focus on the judicial grievances mechanisms, and my friend and colleague Robi from Accountability Counsel will present on other avenues that exist in terms of access to remedy. But before continuing, I would really like to ask our participants to mute themselves, please. Please, can you mute yourself so that we can, you know, run this smoothly? So thank you very much. I was saying that mine would be today to speak about access to remedy, the challenges, especially when it comes to judicial avenues. As you can see, I had initially prepared these slides in English, but I know that we do have a lot of Francophone audience today. I would like maybe to shift into French and to continue my presentation in that language so that our Francophone audience can also feel represented on this panel. So, je disais que je vais m'étaler sur quelques aspects du rapport que nous avons publié aujourd'hui
I was saying that I would expand a little bit my presentation on the report that we are currently launching today. And we are going to focus on access to remedies, but more specifically, judicial remedies. My colleagues will have the opportunity to discuss other remedies that also are mentioned in the document. I'm quickly going to share a number of slides with you, and I will start in terms of my presentation outline and say that we will start with defining what access to remedy is. Thereafter, I will discuss the various types of remedies that exist and that are mentioned in the report. And this will be followed by a discussion on the main obstacles, the main challenges that our communities face when they want to have access to judicial remedies. In conclusion, I will present two recommendations that I can find from this report. Now, what is access to remedy? What does that mean? Access to remedy is a general principle of the law, and this derives from the fact that, and this is a very basic consideration, it derives from the idea that when there is a denial of rights, the law gives a remedy to protect one from damages from the loss of such right. And this appears especially in international law. And that's why this principle was reaffirmed in terms of companies and human rights. And this appears in the reference framework, the international law reference framework that we refer to as the UN guiding principles. According to the UN guiding principles, the goal of a remedy is to counteract or make good any human rights harms that have occurred, and that a violation that may have occurred due to certain activities by corporates. And the objective is for those violations to be paid for by the corporate. Now, remedy must be accessible, it must be prompt, it must be effective, and it must be carried out by independent and impartial bodies. So, in a nutshell, this is what we mean when we talk about access to remedy. Following this quick introduction, since I don't have a lot of time, I will speak about the types of remedies. Ladies and gentlemen, is it possible for delegates to switch their microphones off? Thank you. I am now going to talk about the types of remedies that exist, judicially speaking. And I was saying earlier that we had judicial avenues and non-judicial avenues in terms of remedies, but I will only focus on the judicial avenues. I will focus on the ones that appear in the report. The first type of remedy is represented by national courts and tribunals, which are the ordinary jurisdictions which can be approached to discuss some of the violations that may have occurred in host countries, in home countries. So wherever there is an investment that is made, there are remedies available. But we also have certain types of jurisdiction, which, for example, may depend or may be linked to the various corporate headquarters. And this also needs to be mentioned. Following that, you also have regional tribunals and courts. In Africa, we have a number of them, which are, for example, the African Commission on Human and People's Rights. And those tribunals are referred to as quasi-judicial bodies because they are not courts per se, And so as part of those quasi-judicial bodies, you have the African Commission on Human and People's Rights, you have the African Court on Human and People's Rights, and you have sub-regional courts, which are extremely active, for example, in the ECOWAS region, and which have more or less satisfactory results, which can give a lot of hope to perhaps those who are victims. When we talk about the African Commission, you perhaps are aware of the fact that certain human rights violations have taken place and that court has had to deal with such issues. You have, for example, a number of cases involving Kenya or involving Nigeria, and those cases involved the court. Very unfortunately, however, those bodies are extremely difficult to have access to. Sometimes they are not known by the communities, and some other times their decisions are not applied by, are not abided by the
je vais maintenant m'étaler sur les obstacles qui sont rencontrés.
I'm now going to talk about the challenges that communities may have in terms of access to judicial remedies. There are two types of challenges. You have the legal barriers, and then you have the practical barriers.
Du système juridique dans certains de nos États, des États post-coloniaux, qui souvent n'ont pas réussi à intégrer des réalités culturelles ou traditionnelles dans le système juridique. Cela renvoie, dans le cas des entreprises et des droits de l'homme précisément, à la question ou à l'exemple très connu de l'acquisition des terres, donc la propriété terrienne. Donc, dans beaucoup de situations, le droit traditionnel ou les pratiques culturelles est en déphasage avec le droit formel au niveau étatique. De telle sorte que des communautés sont dépossédées, par exemple, sans avoir des titres fonciers nécessaires pour faire valoir leurs droits devant le système juridique de l'État. Ça, c'est un point important que notre rapport relève. Il y a aussi la question de l'accès à l'information. Comme vous le savez, l'accès à l'information, c'est un droit et selon les pays, effectivement, la mise en œuvre de ce droit peut varier. Mais nous constatons que le plus souvent, ce manque d'accès à l'information constitue véritablement un problème juridique que les communautés rencontrent. Souvent, l'information n'est pas connue. Par exemple, quand un projet commence et que les communautés ne sont même pas il y a d'autres situations dans lesquelles, même lorsque l'information est connue, elle n'est pas accessible ou elle n'est pas facilement accessible par les parties, par les communautés. Alors, vous avez ensuite les restrictions, si on se place au niveau des États desquels souvent ces entreprises proviennent. Vous avez des restrictions en ce qui concerne l'application extraterritoriale du droit de ces pays. Donc, vous avez toute une liste d'affaires, je ne vais pas rentrer dans les détails, dans lesquelles des communautés africaines ont intenté des actions contre des compagnies mères dans leur pays, comme en Grande-Bretagne, aux États-Unis, aux Pays-Bas, dans lesquelles les résultats finalement sont très squelettiques ou minces, parce que finalement, l'interprétation par les juges de ces pays de la compétence extraterritoriale de leur État est restée très restrictive. Puis alors, vous avez des barrières de type pratique. Et le premier que je voudrais mentionner ici, c'est le rétrécissement en fait, de l'espace civique. Ce rétrécissement de l'espace civique se fait sentir dans tous les domaines de l'espace public. Mais il se fait surtout sentir... Il se fait surtout sentir au niveau de la...
Of the microphone. And in Africa, this is manifested through attacks perpetrated against human rights activists. And during COVID, you saw a number of restrictions that sometimes contribute to the increase in attacks against human rights activists. We do have some background noise which does not enable us to perform at our best. Could you kindly switch off your microphones? It would be much appreciated. And there are a number of practices that are related to corruption, and that makes the judicial system unable to hear certain cases since the system is captured by a certain individuals.
Something like this.
Justice, can you please mute yourself? Okay. So, nous avons aussi ce qu'il faut dénommer.
We have also what we would call the lack of resources. Many of our communities lack resources, be it financial resources, but also in terms of knowledge. And sufficient knowledge to take these matters to the courts. And this lack of knowledge is quite rampant in various communities. And there is also the fact that these communities live in remote areas, that specific aspect does not contribute to accessing remedies, efficient remedies. In addition, or should I say, eventually we have the lack of knowledge on litigation strategies, and that must be mentioned because many communities are deprived of the knowledge and required to access these remedies. I am now going to touch on the recommendations. There are quite a number of them, but I would like to focus on two of them. My friend Robi will touch on the others. The first one is aimed at ensuring that the legal framework is strengthened in order to ensure that companies are held accountable by the courts. And it is one of the reasons why ACCA is striving to ensure that at international level, more stringent norms are adopted to actually force these actors involved in these processes to act responsibly. The second recommendation concerns the capacity building of these communities on issues such as advocacy. I am going to stop at this point and wish to thank you for your attention.
Colleague Robi Chacha Mosenda, who will discuss more about non-judicial options for accountability.
Thank you so much, Stephanie and Benjamin, for that amazing introduction. So I don't have PowerPoint presentation slide, but I'm going to try and just join from where Stephanie and Benjamin have left off. My name is Robi Chacha Mosenda. I'm the Communities Associate for Africa at Accountability Counsel, and I'm based in Nairobi, Kenya, supporting communities in Africa to demand for their human rights and environmental rights. So as Benjamin has mentioned, independent accountability mechanisms, which Stephanie had mentioned earlier, and other non-judicial mechanisms are just complementary strategies to judicial mechanisms that Benjamin has spoken about in his presentation. And as part of this, in the sense of being complementary, international finance institutions have offices and independent offices that are specifically established to receive complaints from communities that are negatively affected by the projects that receive support from these institutions. So these offices are called independent accountability mechanisms. And the reason is that they're independent from the management of these institutions. And so they're able to receive complaints independently, but also review and process some of these complaints in a manner that is independent in that sense. They each have slightly different rules and reporting lines, depending on which institution we're talking about here. And some of them are stronger and more independent than others. And the policy team, which includes Stephanie at Accountability Counsel and other organizations, are working towards strengthening some of these offices so that they're more, community friendly, but they're also able to represent the ideals of the communities that they are, meant to serve. So at the moment, there are more than 20 citizen-driven accountability offices that exist for multilateral and bilateral development finance institutions. And just to share a few examples, we have the Africa Development Bank that has the independent review mechanism, the Asia Development Bank that has an accountability mechanism, and that's the name of the office, the Asia Infrastructure Bank that has the project affected people's mechanism, the European Investment Bank that has a complaints mechanism. And so the list goes on and on. And so it's very possible, depending on which institution is financing a particular project, to just check whether there are accountability offices that exist in that sense. And then we have what Stephanie had mentioned, the OECD national contact points, which receive complaints based on the OECD guidelines, which are, in particular countries and not in all countries. And which is another non-judicial accountability framework that has its own rules and policies and procedures there. The advantage that we feel comes in with independent accountability mechanisms is that this can be used alongside other strategies. And a good example we have of that is the case in Lamu, in which we have been working with the community in Lamu to fight the Lamu coal power plant. And so in this case, you find that the Lamu community used different strategies, including a media strategy, public advocacy, the use of protests, but also a court process. And sometimes for some mechanisms, they would allow for parallel proceedings where you have a court process that runs concurrently with a complaints process with this independent offices. So some of the advantages of using the independent accountability mechanisms is that, one, it lowers the barriers to access in the sense that it is a less formal process. Lawyers are not necessary in this process. And then the eligibility rules are way simpler. And so the threshold you find for some of these independent accountability mechanisms are slightly lower than what you find in other, like for example, in the judicial process. And then the second advantage is that this process is community driven in the sense that communities are able to represent and speak for themselves. And then when the system operates correctly, they're a meaningful partner in the design of solutions as opposed to solutions being designed for them. And so through the independent accountability mechanisms, what most of these offices push for is to have an interface with the communities directly, but also to have a consultation with them towards what works best for their cases. The third advantage is that independent accountability mechanisms are less resource intensive. The documentation for this is way simpler. And although there are delays in the process, they should be less burdensome and are less time consuming than if you go through the litigation way. And as Benjamin had mentioned earlier, some of the challenges that exist in terms of the judicial mechanism is that in most instances, there's a cost implication to it that most communities cannot be able to afford. You have time constraints where court cases in some countries take too long and drag for too long. And then there's lack of available public interest lawyers who are experienced in using the range of accountability tools. And often there's a geographic distance between the investment sites and where the lawyers and courts exist. So independent accountability mechanisms are sort of a way to reduce some of these barriers and interdicts so that community are able to access, remedy, but also able to represent on their causes directly with these institutions. But then even in the sense of independent accountability mechanisms, there's still a limitation to access to remedy. And so in this sense, there are accountability gaps where, in most cases, many financial flows still lack such mechanisms. And a good example is, the Chinese situation where for most of the financial flows, there's a difficulty with getting a mechanism that would work for communities. And then there's a lack of transparency about investment chains, which makes it difficult for communities to understand the information. And Stephanie had touched on this earlier. There's a low awareness among communities and community members and their advocates on these mechanisms, which are usually underused. And so there's no linkage between, information and these mechanisms that exist. And then there are weaknesses in the system, such as the non-binding nature of these mechanisms and the reports that they produce from the processes. There are barriers to parallel proceedings where communities are not able to go to use a judicial mechanism, but also utilize a non-judicial mechanism. There are opportunities for the board of the international finance institutions to prevent investigations. Are also, sort of limited in some nature. And this is, I think, because the board members represent different countries. And so for some instances, it's difficult for them to raise. And so there are reforms that are needed and are ongoing. And at the moment, the Africa Development Bank's independent review mechanism is undergoing a review that is, receiving public comments. And then there's a lack of actual remedy because a lack of consequences for failures to implement action plans that are got from these agreements and actually resolve identified non-compliance by these institutions. We're more likely to see policy changes than actual remedy for communities that are harmed. I'll ask Stephanie to pull up the recommendations bit, which we pulled out from the report that we did with ACCA, that some of them touch on investors and others also touch on communities, but also on stakeholders as well. So the first of the recommendations is that investors must, expand their viability and improve the effectiveness of non-judicial accountability frameworks. And this is because the non-judicial accountability frameworks reduce some of the barriers that we see in the judicial processes. And so it's important for investors to inform communities when they're investing that there are mechanisms that are available for communities to use, but also allow communities to understand what these mechanisms mean for them and how they can approach them and access them. The second recommendation is for communities to benefit and to benefit from increased advocacy support with greater awareness, knowledge, and resources alongside legal protection from retaliation. So in most instances, what we've seen as Accountability Counsel from the cases we do with communities, there has been a lot of retaliation against human rights defenders, but also community members who are willing to speak up on the challenges they face with these projects. And so it's important for communities to benefit from advocacy and support so that in instances where this retaliation is too much, to get support from other organizations, but also partners to bring in some support to assist communities to be able to, have awareness on what these cases present, but also in terms of strategy, and then in terms of knowledge, but also resources, so that there's sort of a barrier, or rather some sort of balance between the retaliation and the work that these activists do for communities on the ground. And then lastly, there's a need for all stakeholders to focus on actual remedy in addition to access to remedy. And by this we mean, commitments must be backed by, resources and funds. And there should be consequences for inaction in instances where some of these project companies or the institutions do not comply with, the commitments that they bring along in the sense of non-judicial mechanisms and those processes. Thank you so much. I think I'll leave the rest of the time for any questions and answers and interventions from participants.
Thank you so much, Robbie. So we've heard from Benjamin and Robi about the challenges on accessing accountability and remedy for African communities. We now have the opportunity to hear from additional advocates who have worked directly with communities in engaging with these challenges and with these struggles, and whose views inform the report that we're discussing today. And so I would like to first turn it over to Mr. Omar Al-Mawi from the Decolonize Coalition in Kenya. Mr. Omar, we would love to hear from you for a couple of minutes, if you can share.
Thanks, Stephanie, and good afternoon, good morning, good evening, depending on where you're coming from in this part of the globe, to everyone. I think this has been a very, very good report. And if you'll allow me for at least 2 to 3 minutes, I want to underscore the importance of, one, the community being the ones that are leading this process of trying to get accountability on different investment projects, and also the importance of the financiers of these projects and other financial institutions to really pay attention to what the community is saying. And to be able to do this, I would want to, one, start by saying that many a times when these projects go to the communities, they are only consulted as far as, ticking the boxes so that the investors and the government and everyone that's involved to say that these people have been consulted. But it's not necessarily trying to find from them whether this is something that they want to see through, or do they have other different things or suggestions which they think should be given a priority. And I'm saying this because, the communities are the experts when it comes to these things that are coming to their ground. They know what's needed in that particular region. They are very dependent on the natural resources that are available in these areas, which most of the time are going to be affected by some of these development projects that are coming to them. And I'll be using the example of Lamu to at least make some practical examples of how they've been able to see this through. So, and by paying attention to what the community are saying, you are able to, one, learn what they really want and how is it the best way of doing it. You are also able to ensure that for the financiers, you are also able to ensure that you minimize as much animosity or any challenges that you might get on the project. So you get to know what they want, and you don't necessarily spend a lot of resources to do a project which ends up being cancelled because the community are against it. It's also a sustainable way of seeing your investments through, because most of these projects have a very long lifespan. You're talking about anywhere between 15 to 25 years. And if where you're taking these projects to, you don't have the blessings of this community that are living there. These are the people you're expecting to come and work in your investment or in your projects. They're the same people that you are going to be living near them, and therefore you definitely depend on them on security, among different other things. And therefore, to be able to push and have these projects through, it's important that these communities are given their place as an important stakeholder in these projects, and definitely their voice to be heard. And also, one of the other things I want to really mention is, as far as those who are coming to support communities to achieve or get different rights that we want them to get in different financial institutions, be it by accessing remedy through court or through financial institutions, among different other ways. It's important to let the community lead this process. And also, while we are interacting with them, to have a way of exchanging and making sure that they also understand how the processes work. Because the unfortunate thing is, most of us in the NGO sectors, we depend on donor funding. And we are only able to do what we can when we have this funding. And therefore, these communities need to have this knowledge, so that if in any case we're not able to go to them and support them to do what they need to do, at least we've already transferred that knowledge to them, and they're able to access these different remedy sources to be able to get the rights. I also want to mention that it's sad that most of these projects going to the community without necessarily them being involved affect them a really big deal. And the sad thing is most of these remedy processes, it's the person who's being affected that has to go to court or to access them. And it's even sadder because the person who, at least as a general principle of law, the person who alleges or the person who's complaining is the one that has to prove their case. And most of the time, being the community, they're the ones who want to go to court. They have to find experts that need to prove their case. And it's even worse because most of these projects go to communities that are quite marginalized. They don't have the knowledge, they don't have the resources, these developers or these different people normally think that they can get away with it because they don't have a voice to be able to get their issues out, and therefore it becomes a very expensive process. And the same people that are going to be affected are the same people that have to find a way of finance and making sure that they get these remedies. And therefore, I will want to finish by saying that for those people who are representing different financial institutions who are on this call today, I would really implore to them and ask them to at least try, when they're taking these development projects or these different projects to the community, to make sure that they've done all the necessary due diligence to know that it's something that's going to develop and improve the living standards of these community members and these different communities, rather than continue to burden them and affect them and their loved ones. I think I will stop there. Thanks, Stephen.
Thank you very much, Omar. Our next speaker will be Mr. Daniel Cece from Namati, Sierra Leone.
Yeah, thanks very much, Stephanie. An opportunity for us to share our experience and reflections on the reports and the tribunal. Thanks very much. We at Namati, we work predominantly with communities that are hosting large-scale investment in the country. And because we know very well that our judicial system is a problem, and that it's very difficult to seek remedy, we are using the legal empowerment approach. We are in our frontline workers, the paralegals, work with communities. They teach them the law, the processes, and they understand where to go for what. And in this process, we found out that it's less expensive, and the communities, not only the case at hand they will handle, but they will be taught how to approach similar situations in future. And that has worked so well that if you get communities empowered, you are able to get this community to hold the leaders accountable, as well as be able to get them to resist any kind of intimidation from the authorities. I'll just give you an example of a case that I was used in the report. That after the 2,000 hectares of land was leased to a foreign national, and without the knowledge, the approval of the actual landholding families. That is, the member of parliament and the paramount chief did that. And they only saw people working on the land, not knowing exactly what happened. All payments will pass through these authorities, and they will stifle whatever effort the community makes in terms of seeking remedy. And what happened is that because of the paralegals' presence, they are going through the law, the processes, the bodies, people empowering them, they were able to get remedy or to be able to resist. First, the payment that was going through the paramount chief was stopped. This guy able to get the MP's hand off the whole thing. And even after all of this one, we still see the communities are able to take actions on certain things for themselves. Although in some instances, they will not be able to take action. For example, when eventually they wanted to get the land back and the company was into the land, that one was body something. At that point, you are able to get Namati, and we are able to go to courts and get remedy from them. That remedy also takes a lot of time for us to get the courts to actually rule in their favor. But for the other things, they were able to handle by themselves because of the presence of the paralegals and the different processes the paralegal went through with them. And now people are empowered and they're able to move on with some of the activities on their own.
Okay, thank you very much for those reflections, Daniel. And so we've heard a lot of substance today and a lot of topics. And looking at the participant list, I'm seeing so many advocates that Accountability Counsel and ACCA has worked with over the years, and I know who are doing a lot of great work on the continent and other parts of the world. So we'd love to open it up now to Q&A, and but not just Q&A, more of a discussion, because as I mentioned, we're all doing this work together, and so we'd love to hear your perspectives and your experiences. I've already received some questions in the chat, so I'm going to go ahead and ask one of them from Diana Mochoge. She said, I have a question. The challenge with international financial institutions' accountability mechanisms is the issue of feedback and follow-up after a report is done. What happens to these recommendations, and how can they be made more enforceable? And so maybe I'll turn that over to Robi to start. I'm also happy to jump in with some feedback there.
Yeah, thanks a lot, Stephanie. I think you're right in terms of the gap between follow-up on the recommendations with communities, and some of it might be related to resources, either by the project company that's involved in the process, but also secondly, because of the fact that, and as I mentioned, some of this, for some of these institutions, these recommendations are non-binding. And so, if you go through sort of a dispute resolution, for example, in the context of
par exemple.
So if you go through a dispute resolution process in the context of a mechanism, what you find is some of these recommendations throughout the process, and even the involvement of parties in the process, is basically voluntary. And so even during follow-up, it's sort of hard to impose and sort of push them to do it. And so what most of us are doing, and Stephanie will sort of speak on this, is pushing for sort of a policy advocacy process to include the fact that once you get recommendations from the process, it can then be easy for that to turn into actual remedy that would then benefit some of these communities. And so that's the gap we've seen most of the time. One of the examples is to have a remedy fund that would be in place for when some of these instances happen, that can be able to buffer these communities from harm in the process.
Yes, just to build off of that, ensuring that throughout the process that recommendations are not just developed by the mechanism, but that the management of these institutions are required to actually work with communities to develop an action plan to address the harm, which is sometimes a gap that we're seeing. We're seeing that the action plans coming out of maybe a compliance review investigation are not speaking to the detailed grievances, and maybe are more policy level actions or other things. And so that's definitely a challenge. And from our policy advocacy standpoint, we try to make sure that there's pressure on management coming from the board of directors, the shareholder governments, to actually work with communities to address these harms. And as Robi mentioned, resources for remedy. So maybe there is an action plan available, or there's an agreement that has been made, but where will the resources come from to see these actions through? And so ensuring that there's a pot of money, maybe the shareholder governments donate that money, or it's a part of the client agreement that from the beginning, there's a contribution that maybe the client can get back if there are no issues. We're still exploring the best modalities, but there is overall a need to really have those resources to see things through. Our next question comes from Maurice Odahambo from Kenya, asking, is the report speaking to implementing organization human rights due diligence? I think it should, and CSOs and project affected people should be a part of the process. So essentially, what is the role of human rights due diligence in this whole conversation? Benjamin, would you like to take that question?
Yes, thank you very much. Thank you very much. I think this is a very interesting question in a sense that it touches some of the main and most important obligations that actually fall upon business enterprises. So the issue around human rights due diligence is a very important one. And human rights due diligence has a number of components. And obviously, some of these aspects are really interlinked with the issues around access to remedy. First of all, when you think about access to information, or all the FPIC principle, the free, prior, and informed consent principle. So most of the stages of the implementation of FPIC imply a certain implementation or application by the private investor of human rights due diligence standards. For instance, the obligation to consult the local communities, the obligation to disclose a number of information to the local communities. And also, when you think of some legal procedures before courts, it's important to look at that human rights due diligence, especially when it comes to see the relationship between a parent company and actually a subsidiary. So human rights due diligence do play an important role in the whole issue around access to remedy. And I think in terms of the implication of civil society organizations and PAPs, I'm not too sure if I have understood that part of the question, but I would like to mention that yes, what we are saying here and what we do, especially in ACCA, is to try to create that interconnection between our civil society organizations in a powerful coalition that can actually advocate for these important issues, but also that can help our communities and our organizations to get more resources in terms especially of knowledge to face these pressing issues. So ACCA specifically as a partnership with PAP, I think if it's the same PAP, the Pan-African Parliament that is mentioned in the question, we have done a few things together in the past, and we are still collaborating on some of these issues, and we hope that in the future we can even strengthen this collaboration so that PAPs, even if it has very limited power for now, PAPs can also play a role in this process together with our organizations. That's what I can say on this question. I will leave it here for now.
Thanks, Benjamin. The next comment is in French, but I'll do a quick summation from Adrienne Akilamali, basically saying that, this issue or this theme around accountability mechanisms is interesting, but there's a question of how do the communities even know the details of who's financing the project and the financing arrangement? And without that information, it's hard to really formulate a recourse and to engage in these processes without even knowing how they're being financed and who's financing them, which is definitely an important issue that we've touched on during the presentation. I may turn it over now, Farai. Farai, you've put in a great comment in the chat box. Would you like to just read it out to share what you were intending to say?
Hello.
Yes, please.
Hello. Can I proceed?
Yes, please.
Okay, thank you very much. I was looking at the unequal power balance between governments and corporations on one side and the communities on the other side. And especially looking at the natural resource sector, where there is a lot of loss that the communities are engaging. Now, I feel that these remedies work better if there is community action that is ongoing, coupled with also media attention highlighting the problem. Therefore, I was asking whether there is that drive. I've not read the report, how civil society can support community actions on the ground, which can then push, and show the agents of the matter to these remedial processes. Thank you. I'm sorry, it's a bit windy, but I'm sure you get what I'm trying to say.
Yeah, Robbie, Benjamin, feel free to jump in if you have any thoughts on that.
Yeah, I think Robi has already mentioned something around protest, and maybe Robi wants to go a little bit deeper in that.
Yeah, thank you, Benjamin, and thanks, Farai, for your comment. As I mentioned earlier, the beauty about the independent accountability mechanisms is that it can be used concurrently with other strategies. And what we've seen, and this is the ideal situation for some of these instances, is it's very rare for us to advise that a community should only bank on the independent accountability mechanisms processes. And that's because we in most instances can't evaluate when the process will be done, or whether it will pass the eligibility test of these institutions. And so what we advise is that it can be used concurrently with other strategies that the community would feel are important, and those includes media advocacy, policy advocacy, reaching out to leaders directly, but also judicial mechanisms in instances where the independent accountability mechanisms allow for parallel proceedings in that scenario. So one of the reasons, and we've seen this in the Save Lamu example, is that when you have all these things running together, you sort of get a lot from it, because you're able to get small wins from different sources of strategies that would then lead up to the bigger goal of getting justice for the community.
Thank you. So I just want to flag that we're coming close to the end of our time. We said that we would go to 15 past, but we do have a lot of great questions in the chat. So if it would be okay, feel free to jump off if you have to jump off, but maybe we can stay for at least 10 more minutes to try to get through some more questions, if that works for you all. Another question that Diana asked that I will quickly respond to is whether all other local remedies are supposed to be exhausted before communities can access an independent accountability mechanism. And so just from our policy standpoint, we recommend that communities not have to exhaust all local remedies, especially project level grievance mechanisms, because there may not be a level of trust in those mechanisms, or the mechanisms may not be effective, or there may be retaliation risk around engaging with local remedies. Some independent accountability mechanisms do require a level of engagement with management or a project level grievance mechanism before going to the IAM, but others do not. And so it kind of depends on which mechanism you're trying to access. The next question from Alan, a question to Robi: have there been any positive examples of IFIs responding positively to community complaints?
Thanks a lot, Alan, for that question. So to begin with, I don't know whether he meant independent financial institutions or independent accountability mechanisms, because the two are sort of separate but work together towards more of the same thing. So just to explain in brief, what happens is when the independent financial institutions, offer, I think he meant the independent independent accountability mechanisms. So to answer your question in brief, yes, there have been there have been examples where this independent accountability mechanisms have responded positively to communities, and the reason is that these mechanisms are citizen-driven, and so ideally what they are intended and meant for is to receive complaints from communities and individuals that have been affected or could be affected by the projects that are undertaken by the international finance institutions that they're tied to, and then process those through their policies and procedures. And at the moment, Accountability Council has something that the research team created called the Accountability Council. And just to look through it, I can flag about 181 complaints that have been, included with outputs. And so when it means, the processes were concluded and there were outputs or other recommendations to it in different accountability mechanisms. And now the question remains whether some of these outputs would then turn into actual remedy for communities. And just to read out a few, I think the African Development Bank's IRM has about 4 that they've sort of closed and gone through the whole process and gotten outputs from it. But the second question then becomes whether these outputs have turned into actual remedy for these communities.
Yeah, thank you for that, Robi. I don't know if anyone from Bank Information Center or Joy for Children in Uganda is on the call, but there was also a positive example in Uganda concerning a transport sector project that was taken to the inspection panel of the World Bank. And the project ended up having negative impacts on young women and girls in the community. And as a part of the investigation, a lot of these harms to the young women were addressed. And also importantly, the World Bank has changed its approach to assessing gender impacts, particularly as they pertain to transport sector projects. And so that is something that we have seen. So there are going to be a couple more questions. I'm going to read one from Timo, and then Mr. James Farole Jarso, I know has also been wanting to ask a question. So I think they may have to be the last ones for today, but we look forward to continuing the conversation. So Timo has asked, a question to Stephanie: to what extent can monitoring and evaluation methodology be embedded in these projects as an early warning system? And I think that is a great point, and it gets back to the human rights due diligence question, and what are the processes and protections in place to ensure that the projects are being implemented properly and that negative impacts are being caught well before they escalate and communities have to seek justice. I know that our a great advocate is on the call right now, Mr. Alfred Brownell from Liberia, from Green Advocates. But briefly, just to touch on a case that they have worked on with the Overseas Private Investment Corporation concerning an investment there. One of the key findings from the investigation that was carried out by the accountability mechanism in that case was that the monitoring and evaluation of the project was just insufficient. They were relying on clients to send self-reported monitoring reports back to the institution instead of doing on the ground monitoring that could have caught some of these issues earlier. Alfred, don't want to put you on the spot, but I don't know if you have anything else to add on that. But as a part of our policy advocacy, we advocate for a holistic approach to preventing these harms. So make sure that there's community consultation from the beginning throughout the project. Make sure that there's effective monitoring and not just a top-down approach to monitoring, but a community participatory monitoring. And there are a lot of great methodologies on community monitoring and trusting the local communities with their expertise to really report on and understand these impacts. And then, of course, when, despite all of these efforts, things do go wrong, having an effective system to effectively address the grievances. Yes, but Alfred, please jump in.
Well, sorry, you're not actually putting me on the spot. Thank you so much for what a wonderful presentation by all of the panel. Wow. This is so enriching, and I'm so happy to be part of this arrangement, and that you folks use the so-called Buchanan renewable energy, one of the cases in this very report. And yes, you're very much right on the whole issue of trying to put in place a process for monitoring and evaluation. And I think if you went back and listened to all of the speakers, from the folks from Lamu and the case from Sierra Leone, what Namati and others have said, and you look at what we are talking about. So just think about what we are dealing with. You're dealing with these massive transnational corporations. And most of them, if you look at their portfolio, there's no way you can compare that to what's happening in these very poor countries, right? And they come in, so there's already an unequal relationship even between the corporations and the government, especially if they've been financed by the international financial institutions like the IFC. So then the government take these massive, financial giants and place them in very poor communities. Even the government, forget about the communities now, even the governments do not have the capacity to monitor what is going on. So they leave these poor communities just at the mercy of what these folks can do. And Buchanan Renewable is an example of that. First and foremost, like one of the speakers said, there's no consultation. The government make a decision that it is great. In the case of Buchanan Renewable, look at the idea, lofty ideas, post-war recovery from Liberia, small rubber farmers. It's proposed that we're going and we take down your old grow rubber trays, we'll plant new ones, and then we pay you for the trays. Who's not going to buy that? An investment that is guaranteed by the World Bank through its mega guarantee, funded by the IFC, supported by the Overseas Private Investment Corporation, supported by the Swedish Development Bank. Who would not think there's going to be a lofty deal? Missing are all the issues about consultation, someone talk about free, prior, informed consents, and the whole concept of monitoring and evaluation, what's going to come up. And then they are dumped to these poor communities, and then all the results start coming up. And most time, like someone said, all of the costs, the farmers lost their farms. They were the only losers in the farm. But you know what? It's not just this small farmers. Don't forget about the other stakeholders who are involved. It ended up affecting poor charcoal producers who were not even accounted for in this process here. It ended up affecting the workers who were not even accounted for in this process here. It ended up affecting the people of Liberia. At the time when Buchanan Renewable came to her zenith, and they had promised to harvest the trees and pay for the trees, what were they doing as well? They decided that it won't be good to harvest the tree and support the power plant in Liberia because they promised They are going to provide electricity for 500,000 homes in Liberia. They changed the result in the end. They targeted big farmers. They shipped the fuel wood to Europe. And the price of charcoal went from being 50 cents a bag, $1 a bag, to $5 United States dollars. The people of Liberia end up subsidizing electricity in Europe. Imagine what this is. So now we come for the accountability, they go to the review, say, yeah, we made some errors, we made some mistakes, we should have done better. And up until today, the poor farmers, the charcoal producers, the workers are still looking for a redress process to address what has happened in the hand of that were called massive harm called across the whole value chain in the beginning of the renewable energy process. And then only the poor. We had to go and take the cost of trying to assist them. We had to go and find accountability counsel to help us. Even the World Bank that finances, that guarantee this process, OPEC that guarantee the Students Bank, they are yet to face what they did to those poor people in Liberia. And this is what we're talking about. That's why this systems are important to ensure that, and I hope those who fund this kind of projects are actually on this call and are listening. Because this harm are serious. And then you come and say, when you displace people, they lose their livelihood. And then young people from those communities start now to trek across the Sahara Desert and jumping on the boats to come to Europe. You're like, oh, no. Why are they coming here? Why are they coming? Why are they crossing? Why are they taking the risks? You forgot that you finance the destruction of their livelihood. So these things are very important. They are all very much tied. So thank you. I know you are not putting me on the record here. I'm very happy to make this contribution. Thank you so much.
Thank you, Alfred. And so, yes, we'll give the last question to Mr. James Jarso, but we will put our contact information in the chat. And so if there are any follow-up questions or the questions that we did not get to, please do feel free to reach out to us, and we hope to keep this conversation going. But Mr. Jarso.
Yes, Stephanie, I've posted my question on the chat if you can just read for.
Okay, let's see. Yes, in Africa, accountability for human rights violations is often a political struggle. Regional human rights mechanisms are often regarded as safety nets for individuals failed by their national jurisdictions. Until 2016, we saw a gradual progress in opening doors to the African Court through state declarations under the Ouagadougou Protocol. Sadly, in the wake of the problematic Ingabire decision, which allowed Rwanda to withdraw from the protocol, we are seeing African states make an about turn on their commitments to avail individuals within their jurisdictions access to the regional court. Is this pushback by states not a grave threat to our push for accountability for corporate violations of human rights, considering the weak positions of victims of the violations? So I'll turn that over to Benjamin, but yeah, can you give an update on the status of the availability of regional courts and this pushback?
Yes, thank you very much again, Stephanie. And I would first of all like to also add on what Stephanie has said before. This is a conversation that is continuing, and maybe for those who don't know, this is the first of a series of webinars that we are going to host on this report. So again, I can see there are many questions that have been asked. Unfortunately, we won't be able to go through all these questions, but obviously we will continue the conversation. We will go deeply into some of these specific issues during our next webinars. But yes, to come back to your question, James, thank you very much. And I think that you are right. You are right. The situation with the regional human rights, African human rights system is quite disappointing one because obviously the African Court for on People and Human Rights is there. But unfortunately, the situation has been in a way that it has not been able to operate in its fullest capacities. And as you know, there were no more than 10 countries that have accepted the declaration under which, that have made the declaration under which the court can have jurisdiction of cases that are brought by individuals and NGOs. So out of these 10 countries in the last few years, 4 have withdrawn. So we are left with only 6, if I'm not mistaken, which is a very challenging situation. And even in those situations where some cases were brought before the court, I have mentioned the Oecd community case before the African court, that was actually brought to the court by the commission, the African Commission. The outcome was very modest. Finally, I don't think the decisions have been implemented by the Kenyan government. And you have also these, the African Commission, the same applies to the African Commission. So many states actually just contend that the decisions of the Commission are not binding, and then they refuse to implement them. We have many cases, including the emblematic Ogoni case. We have also some cases in concerning the DRC, such as the Kiliwa massacre case. A decision was made by the African Commission, but unfortunately, the Congolese government has not yet implemented this decision. Before some sub-regional courts, such as the ECOWAS court, there are a few interesting developments. But again, that court is a classical interstate litigation court. So we have individuals that have the possibility to go before the court, but most of the time the court deny recognizing obligations upon companies. So the decisions that are taken are directed to states, as in a recent case that was delivered in November last year, on a massacre that happened in Liberia. The court has recognized the role of the Guinean state in that massacre, but the Guinean state was actually the only responsible according to the court, and because of this, the fact that regarding the fact that the company is not under the jurisdiction of the court, this couldn't go any way further. So this is the situation regarding the courts on the continent. It's not a very happy one, but yeah, this is the reason why we also think that there is an important role to be played at the national level. How our communities and civil society organizations can develop effective litigation strategies before national courts, so that we can also have some impact there. But again, this is a very holistic situation that should be regarded in a very holistic way. Then not only judicial mechanism would help in this situation. I'm quite convinced that we have to multiply other options, such as non-judicial grievances mechanisms, including communities, protestation, including other avenues that have been also mentioned here. But again, I think this is a continuing conversation. We will have the opportunity to go more deeply into some of these issues and see what are the real challenges. For now, I think we are really happy to be launching this report and to start that conversation.
Great. Again, thank you very much, to everybody for taking time and taking some extra time to join us today. We really look forward to ongoing conversations. Definitely feel free to reach out to Benjamin, to Robi, to myself. I actually don't think that my email address was on that last slide, so I will put that in the chat right now. But do check out the report and be in touch with us. We look forward to engaging with all of you all on these important issues. Thank you.
Thank you very much. Thank you, everyone. Thank you. Bye.
Thank you, everyone. Thanks, Stephanie. Thanks, Benjamin.
Thank you, Robi.
Thank you.
Thanks to our translators.
Yeah.
Bye.
Oh.